Say, man, there's been some updates in this Keefe D. TUPAC murder case. Now, Keefe D. was back in court yesterday for pretrial motions, and his attorney argued before the judge to try to put forth a motion to have the murder charges against his client, Dwayne Keefe D. Davis, dismissed. Now, Keefe D's attorney argument to the judge was that this is a tactical move by the prosecutors to try to pin this case and try to pin these charges on my client, Dwayne Keefe D. Davis. Now, they had all of this evidence decades ago, and they decided not to bring this case. And now all of a sudden that everybody's dead, they want to try to put it on the last living person that was associated with the crime. And the prosecutors argued against that. The judge made her decision. Let's get to the content.
The immunity argument. In 2009, I counted, well, I'll just go through the pages, Your Honor. In that 2009 discussion with the Las Vegas Metro Police Department's officer, Detective Long, on page 3, he says, no intent of arresting Keefe. Page 11, I'm not here to arrest you. I'm not here to arrest you. I'm not going to arrest you. Page 12, you're free to leave. I'm not going to arrest you. You can go wherever you want. Page 103 and number 4, Terrence Brown was still alive, and the detective said I was not going to arrest him. Page 134, I want to close the TUPAC case. Page 138, this is confidential and covered, and you cannot be charged on it. Basically, you have the state was given the information by the LAPD. The LAPD had a immunity agreement with him out of the 2008 confession. You have the state was given the information by the LAPD. The LAPD had a immunity agreement with him out of the 2008 confession. The 2009 confession came by a product of Detective Dupree. Detective Dupree set that up. The only reason he set that up and why my client would have agreed to was that everybody was on the same page, that immunity was going to be provided. If it wasn't, how come he wasn't arrested right then and there? Because he said, I got the gun from Zip Martin, we were in a white Cadillac, I handed it to the back seat, and then Orlando took the gun and shot TUPAC. All of that information is back there in 2009. The decision was made back then not to proceed with the trial. And now it's the state's burden, we believe, to show why they did not go forward and prosecute. They just can't sit here and say, well, he kept talking about it. No, you had that information in the beginning. You should have arrested him back in 2000. It had to be for a tactical advantage. That being, everybody's dead. It leaves Mr. Davis on the hook, and then he can't answer for all of the statements he made after that, other than it was for profit.
State, I think it's better to at least hear it on its merits. Corpus delicti requires that there be corroborating evidence to support a confession. In a homicide case, the Nevada Supreme Court, as you both said, indicated this could be satisfied by proof of death by criminal agency. So I think maybe an example makes the most sense to explain what this concept means. For example, I confess that this morning, as I was driving into work, I killed someone on 3rd and Lewis Avenue. All right, now let's say there's no body ever found, there's no video, there's nothing. It's only my statement that I killed someone that makes this crime exist. However, here, that is not in this case, that isn't the case. There is corpus delicti because Mr. Shakur was shot and eventually passed away from his injury. An autopsy was completed. His death was determined to be homicide by gunshot wound. And ultimately, it's a situation where the crime has been established. that a murder occurred because of the body of Mr. Shakur. So I will deny it on those grounds. Regarding the pre-indictment delay argument, as you both cited, it looks like the standard that's laid out federally in People versus Nelson. I'll use that standard. A delay in prosecution that occurs before the accused is arrested or the complaint is filed, so we're looking at a pre-indictment delay argument. That could potentially constitute a denial of the right to a fair trial and due process of law under both state and federal constitutions. And then determining whether prejudice to the defendant has occurred, the court needs to balance the harm to the defendant against the justification for the delay. Here, it's clear that some of the witnesses are now deceased, and there is definitely evidence that has been lost. However, I do find there is a justification for the delay, and a pretty significant one. Uncovering information on Mr. Shakur's murder was ultimately no easy task. There was the interview in 2009, but it's clear that there was, at the attorney's suggestion, Mr. Davis at that time was not giving full information. He was sort of trying to obscure information and make it very general so that he would not be charged with murder, as his attorney indicated. It was not until ultimately the Constant Street Legend book was released in 2019 that Detective Mock then sought to establish the words in the book are actually defendants and to corroborate those things. The prejudice of the death of those four individuals that have been identified had already occurred at that time. Additionally, it took the next several years to gather that evidence and ultimately led to the June 23rd, 2023 search warrant of defendant's residence. After that search warrant was executed, then the grand jury indicted the defendant after several meetings in September of 2023. Defendant has not provided any evidence to establish the delay was intentionally done to gain a tactical advantage or that the prosecution delayed in bad faith. I don't see that the state really does gain any sort of tactical advantage here. I still think, it's a bit of an uphill battle for them given what they have. And ultimately, they can't get complete justice for Mr. Shakur because of the deaths of those other people, including Mr. Anderson, who's the alleged shooter in this incident. And so I ultimately don't see that this is a situation where the state really got any advantage by delaying, and in fact is themselves hindered. And so overall, I'm going to deny on the pre-indictment delay argument and turn to the immunity argument. It's fairly clear that the state of Nevada has never offered the defendant any sort of immunity. The federal government did in some capacity, but it doesn't appear to be complete transactional immunity. The court agrees that the interview defendant gave to the federal authorities in 1998 cannot be used against him as per the terms of the agreement. I think that's something that the state also conceded in their motion work. However, the defendant has not produced any sort of agreement showing the federal government offered him transactional immunity from ever being prosecuted for this crime. In the 2009 interview that's been referenced multiple times throughout these arguments, Detective Long's assurances of not arresting Mr. Davis really go to whether he was in custody for purposes of Miranda or things like that. Additionally, he didn't have a warrant at the time, so that was an accurate statement of the law. There's nothing in that that can imply transactional immunity. Additionally, his defendant's attorney's at that time of that 2009 interview with Detective Long kind of show the opposite conclusion, that he is concerned with the defendant being charged with murdering Mr. Shakur, and that, which leads me to believe that Mr. Davis did not have transactional immunity in the view of his attorney, and that's why his attorney advised Mr. Davis to keep at bay. And at that time, Mr. Davis did listen to his attorney, but his subsequent interviews and his self-proclaimed biography did not keep at bay. As the years passed, Mr. Davis revealed additional information on his own volition, and presumably for his own pecuniary interests that connected him to this, the alleged death, or the death of Mr. Shakur, allegedly at Mr. Davis's hands. And I do find the state is entitled to use that information, freely given by defendant with no prompting by governmental authority and released to the public in its prosecution. So I'm going to deny the motion on those grounds. Overall, the motion to dismiss is denied, and the state has prepared the order consistent with this ruling and with its opposition.
Now, Judge Carly Kearney denied a motion filed by Carl Arnold, Davis' defense attorney, Keefe D. During a brief hearing on Tuesday, Arnold alleged the delay in prosecuting Davis for the 1996 murder was in bad faith and violated his client's constitutional rights. Now, I want to back up for a second. Yes, she did deny his motion to have the murder case dismissed. But I want to back up for a second because he made some valid points in his argument. It was pretty lengthy, but he had a lot of good points, and that was supported by the evidence, the investigation, the interviews, the conversations between Keefe D and the prosecutors and the people that was investigating the case at the time. He pointed to all of that evidence, and still they denied it. Now, Carl Arnold talked about the fact that, look, the state the case that the state is bringing, they could have brought this case while some of these folks were still living, and they decided not to do so. For what reason, I don't know. Now, I'm not into all of the conspiracy theories and this, that, and the other, but I don't know why it took all this time for these folks to even find a suspect or charge somebody or have a case and have it over and done with at this point. You dig what I'm saying? Now, Carl Arnold was saying, like, look, bro, like, the things that Keefe D did say, he was under the impression that he had immunity. Otherwise, he wouldn't have said what he said. Now, he also argued that the prosecutors want to pick him up and charge him just now because, he out there talking about it. Because Keefe D wrote a book. He talked about some things and shared some things in there. Was that covered under the immunity deal that he had with prosecutors? I do not know. And he also did some YouTube interviews on a couple of different platforms. GuddaTV was one of them, where he also shared some more information. And the prosecutor said it was the information, it was the additional information that he put out there into the public that made us pounce on this and bring this case against Keefe D. Now, his attorney, Carl Arnold, was arguing that, look, bro, he talking about it. So what does that mean in terms of the evidence of the case? If y'all had the evidence to prosecute him, if y'all had the evidence to prosecute Keefe D, y'all should have prosecuted him a long time ago, but y'all chose not to. But the judge, she just wasn't going for it, man. She's saying that the prosecutors and they got enough evidence to bring this case against him based on, whatever the particulars was and what he was covered under the immunity, and he spoke outside of that. So when he spoke outside of that, he's not covered. So, hey, it's a valid case. So, hey, man, we'll see where it go, man. The judge did mention that they're going to be back in court on February the 11th. So we'll do this again then, man. Until then, I'll get at y'all on the next one, man. Y'all be smooth. I'm out.